Then comes the forms of evidence. The first is oral evidence, which is called testimony. Any person who is said to be the witness of the case has to come to the court and has to give oral evidence in the witness box in the court. Other than that, any expert whose opinion is required on the case, for example doctors, shall also sometimes have to come to the court and should have to stand in the witness box to give their oral evidence to the court, and that will be called the testimony. The second form is the real evidence. Materials from which court may draw conclusions or inferences from using its own senses is called real evidence. Like the gun from the crime scene shall be the real evidence. The demeanor in which the witness is acting is the real evidence. Photographs and films related to the crime are also the real evidence. Blood stained from the shoes are also the real evidence. Moreover, the fingerprints of a person at the crime scene shall also be considered as the real evidence of the case. Often real evidence cannot be produced in the court. For example, stolen car. Stolen car cannot be produced in the court. In that case, the court might have to make do with the oral evidence describing the thing in question. Whilst it may not be possible to bring the thing to the court, it may be possible to take the court to the thing, so the judges and jury could go to the crime scene or the thing related to the crime to see the real evidence, to hold the substance, the weightage to the evidence, that is the real evidence. In other words, for the court to up sticks and go and look at the thing and or the crime scene. This most commonly happens when the court is persuaded that the tribunal effect would be helped by having a view of the place where the offense took place. So the court shall be persuaded first that it will help the court understand the fact in the matter if the jury or the judges will go and have a look at the crime scene. It is still called by the lawyers locus in quo. In the Latin, its meaning is place in which the thing might have happened. If it is a jury trial, then the jury, together with the judge, defendant, counsel, and shorthand writer, will attend the place at any time before the summing up has finished. The third form of evidence is the documentary evidence. The word document includes anything which information of any description is recorded. This includes books, letters, newspapers, computer printouts, video films.